In answering the question of what is access to justice, well, there are lots of ways to talk about justice. Justice maybe equals fairness. Maybe justice is upholding moral principles. Maybe justice is about the rule of law. All of these things have value, but in the context of talking about access to justice, often when we're talking about access to justice, at the core of what we're talking about, really, it's people's ability to resolve a legal problem. That's why they're trying to access justice. So that legal problem could be all sorts of different things. It could be a dispute with a neighbour about a fence or a boundary. There are lots of those kinds of disputes. But it could also be a dispute with the government. If you think a wrong has been done against you, regardless of whether that wrong is done by a neighbour or the government, then you need to know how to resolve that problem you have. And there are two things you're going to need in order to resolve that problem. You're going to need knowledge, how to do so, how to resolve that problem, and you're going to need a forum in which to do so. You're going to need a space to be heard in. So these are the kind of two key elements we can talk about as elements of access to justice: knowledge and forum. If we start with knowledge as an element of access to justice, and really this is about whether a non-lawyer can know the law, just have a think about how easy it is to know the law. Even lawyers find the law hard to understand at times. So for non-lawyers trying to solve a legal problem, they're going to find the law potentially very hard to find and to understand. Think about the work you've done previously in this unit on finding the law in cases and statutes. To get to the law, you have to understand the doctrine of precedent. You have to be able to identify the ratio decidendi and the obiter dicta in a case. To find the law in a statute, you have to know the different approaches to and rules of statutory interpretation. All of this stuff comes after you've found the cases and the statutes in the first place, and after you've figured out what all the things like the headnote, the citation, stuff like that means. Once you've figured out what court the case was heard in when you're looking at a case, why it matters where the case was heard, there's a lot for a lawyer to get through before they even start looking for the law in the cases and statutes. Then there's the problem of accessing this knowledge. And remember here that the only reason you have access and the reason I have access to Westlaw and Lexis is because CQ University pays for those services. A lot of legal information is behind a paywall. Now that isn't to say that there isn't good free information out there. Ostly, for example, is a great free service. But you have to know about it. You have to know where to look, and you have to know how to use it. Finally, when it comes to knowing the law, we also have to factor in that law is always changing. Whether it's through cases being decided or new legislation being passed, laws change. They're revoked, they're replaced, they're expanded on in all sorts of different ways. And if your only way of getting access to legal knowledge is to go to a local community library and read a 10-year-old book, well, the law might have changed since that book was written. Even online sources, which we generally think of as being up to date, can be outdated. So that means that knowing the law is hard. Then we can move on to the idea of forum as an element of access to justice, and the prospect of a non-lawyer being heard when they raise their legal problem. The starting point here is that Australia is an adversarial justice system. Parties to a legal dispute are represented by lawyers advocating on their behalf. It's the party's responsibility to present their own arguments and attack or rebut the arguments of the other side. This is how we get to the idea of a judge as a referee, making sure that rules are observed, deciding on the case, but not really doing much else. Now, of course, negotiation, out-of-court settlement, these kinds of things are an important part of adversarial justice, but the focus is really on two sides up against one another. We could compare this system of adversarial justice to what's called inquisitorial systems of justice. In those systems, places like France, the judge plays a central role in collecting evidence, doing things like interviewing witnesses. But Australia isn't an inquisitorial system, it's an adversarial legal system. So the Australian legal system is really built on the idea of two experts, two lawyers, fighting it out, with the judge not there to help them in that process, but just to be an arbiter. They're the arbiter, not the assistant. If you're a non-lawyer and you don't have representation, then when you get to court, it's going to be really hard for you to be heard because you aren't the expert that the system was designed around. You don't know about the complex processes that the system has, about when you can speak, how to file forms, what the forms need to say. The legal system is a very particular system with its own way of doing things. Even little things like legal Latin. In the law, we actually pronounce them in what would be a technically incorrect way if you were trying to learn Latin. We pronounce them in a legal way. Access to justice requires access to knowledge of the law and access to a forum in which you can resolve your legal problem. And both of those things, as we've just seen, are hard for non-lawyers to achieve. So that means a lot of people need a legal representative, either to give them advice or to act on their behalf in a legal dispute, or both. Lawyers are the experts who can provide this advice, provide access to legal knowledge. They also understand complex legal processes, they have experience of them, and they can speak on clients' behalf because lawyers are advocates. Their job is to advocate for someone, for an argument, for a position. So lawyers have developed that skill of constructing an argument, of knowing what elements of an argument are going to be relevant, what elements are going to make for a strong argument. And it's those strong arguments that are going to help you resolve your legal problem. So legal representation ends up being often a really important prerequisite for access to justice. This is a problem because legal representation is often expensive. So if we look at the cost of legal services, fees generally range between $200 and $700 an hour. And it's important to recognize that that cost, which in and of itself is a lot of money, is additional to the cost of proceedings. So there's always going to be court costs as well. So about 10 years ago, the Commonwealth Attorney General's Department estimated the cost of hearings in federal matters at $100,000 to $110,000 for federal court matters, $6,500 to $8,800 for family court matters, and then $7,350 to $8,800 for administrative appeals. Now, remember that those figures are about 10 years old, so they're no doubt going to have risen since they were calculated. We're waiting for more. We'll see what happens. But that's a huge amount of money. Legal services, as a result, aren't cheap. And because lawyers provide services that are often important for access to justice, we can end up with a situation like this. Or at very least, a situation where there's a perception that this is how the system works, where access to justice is limited by how much you can pay for it. And then we have to remember that there are usually two sides, at least, to a dispute. That means that in a legal dispute, there can be a situation where one party has representation and the other, due to the cost of legal services, doesn't. So they would be what we would call self-represented litigants. They're self-representing. When you have self-represented litigants, there's the risk that the process will become one-sided, with only the represented party being heard properly. And this is obviously bad for the unrepresented party, the self-representing litigant, who's going to be at a disadvantage in the process. But it's also bad for everyone. Think about the lawyer on the other side. That lawyer is trained to face off against another expert. Now, all of a sudden, they have to manage this situation where they're up against a non-lawyer. They have to figure out how they're going to change their approach. Judges also, they're going to have to change their approach. Judges in this situation where you have one party with representation and the other without are going to often find themselves trying to level the playing field. Judges are going to have to do more than be that arbiter that the adversarial justice system sets them up to be and trains them to be. So the adversarial system that we have in Australia isn't really set up for self-represented litigants, and the accommodations, the adjustments that other people in the system have to make, the things that judges have to do, the things that other lawyers have to do, those take time and they take resources. So that means that the justice system can end up suffering, with cases taking longer, costing more, so everybody suffers. There are three options really. Either you make the law simpler, you make help cheaper so that there's access to justice through the courts, or option three, you provide alternatives to the courts so that people have other ways to solve their legal problems. More realistically, you do a combination of all three. If we start with making the law simpler, what we're doing here is making the law easier to understand so that a non-lawyer has less obstacles to being heard. We can streamline the complex processes that we have in the justice system so that hopefully a non-lawyer might be able to get through them without a lawyer guiding them. Now, that might be a bit lofty of a goal, but even if we can't get to that point, streamlining can still make things simpler and quicker. This has the benefit of also making processes cheaper, because if they're quicker, they'll cost less. The Victorian Civil Procedure Act is a good example of an attempt to streamline legal processes. Its overarching purpose is to facilitate the just, efficient, timely and cost-effective resolution of real issues in the dispute. As Chief Justice Black said, the Act provides case management powers to judges so that they can respond to and prevent things like overrepresentation and excessive materials. That means that judges can ensure that the costs of representation are reasonable and proportionate relative to the complexity of the matter, and judges have powers to sanction lawyers here. They can make the lawyers pay as well as the parties. Judges can do all of these things to try to make sure that legal disputes are resolved as quickly, inexpensively, and efficiently as possible. That means that even if you need legal services to help solve your problem, you need less legal services. And the overall bill for fixing your legal problem, is going to be lower. The Victorian Act also provides for referrals to ADR where appropriate, which is something we'll talk about later. But the big thing for now is that the Civil Procedure Act is really trying to change the culture of litigation. It's trying to make it more efficient and less expensive. Another thing that can help keep costs down is unbundling. Unbundling is a way of moving away from the idea of a lawyer being your representative, the idea of retaining a lawyer. Typically, in legal disputes, you would retain a lawyer. You would ask them to manage the whole matter, the whole thing. But maybe you don't need help for the whole thing. And in that situation, unbundling can be helpful. What you do here is you unbundle your case and you ask a lawyer to just complete specific tasks. That means you're doing some of the work on the matter alone, you're doing some with a lawyer. A client might ask a lawyer to appear in court for them. They might ask the lawyer to draft a contract, or review some documents, or do due diligence. Those kinds of things. But not take on the whole matter. The matter is unbundled. It's been split apart. What that means, importantly really, is that the client leads the case. That means that the client has to still manage the case. They have to run the overarching process of this legal dispute, this legal matter themselves. So that's quite a lot of responsibility. That's a lot of burden on the individual non-lawyer litigant. Managing that burden is arguably made a bit easier by something called the plain English movement. This is the idea of using plain English in law. And since the 1980s, We've seen the development of this plain English movement, this shift towards straightforward, simple writing in law. So that would be in legislation, in court forms, and in other legal documents and drafting as well. A 1987 Victorian Law Reform Commission report was a really important step in that shift towards plain English, but it's still an ongoing process. You can see the changes in plain English very clearly if you look at old statutes versus new ones, so you can just see that difference for yourself very easily. But that doesn't mean that all legal writing is going to be clear or understandable, especially if you're a non-lawyer. Partly that's because not everyone shares the same definition of plain. So just because a particular document is written in plain language doesn't mean we're all going to be writing in the same way. Also, these plain language documents can still be part of a complicated system. So that document and that system can still be confusing to a non-lawyer who's not familiar with the way the legal system works. You have to remember also that case law and the doctrine of precedent, as well as the fact that some statutes are still in force despite being very old, means that there's plenty of law out there that predates the plain English movement. So even if we think that everyone has behaved perfectly in terms of plain English since the 1980s, there's plenty of law out there that isn't in plain English. If you can't solve your legal problem yourself and you can't afford legal representation, then you might be able to get legal aid. Legal aid provides funding for legal advice and representation. Legal aid commissions pay for the lawyer so you as the individual litigant don't have to pay. These commissions, these legal aid commissions, are run by states and territories, so the way in which money is distributed is administered by them. But the funding itself actually comes from a mix of states and the Commonwealth. And there's only so much money available here. And that leads to a situation where there's high demand for legal aid and strict criteria that are in place to try and best distribute what limited funds there are. That leads to an issue of access to legal aid and a question of whether there is enough access. The Law Council of Australia has looked at this quite a bit, and they found that whilst 13% of Australians live under the poverty line, only 8% have access to legal aid. So you can be living in poverty, but still be expected to pay for legal representation. They also found that in 2016, almost 10,000 people every year were unable to get legal representation because they didn't have enough money to pay for it and they couldn't get legal aid. There's only so much money available, and last year the Law Council identified a $310 million shortfall per year in legal assistance funding. That gap hasn't yet been fully plugged, anything like, so that shortfall in funding is still there. If legal aid is providing those without a means to pay for legal representation with a way of accessing justice, then these kinds of figures that the Law Council of Australia has produced really raise the question of whether legal aid, in its current form at least, is ensuring access to justice. But on the other hand, we have to remember that the money for legal aid has to come from somewhere. Alongside legal aid funding, we have community legal centres. These are more oriented towards direct provision of legal services rather than funding for other legal services. Community legal centres, also known as CLCs, provide free legal advice and assistance, and they also engage in policy advocacy. So CLCs will argue for law reform, they'll engage in studies, they'll use research as a platform for legal change. CLCs also provide education in the form of different resources, publications, information sessions, that kind of thing. And through that education, CLCs can provide information on DIY legal problem solving, or they can provide information on how to prevent problems from developing into full-blown legal disputes, hopefully by giving people the information that they need early on. CLCs are independent organizations, but they rely on state and federal funding, and we can really see the impact of the legal assistance funding shortfall when we look at community legal centres. The situation isn't good. CLCs estimate that they're turning away more than 160,000 people each year. And then we have the question about whether the limits on funding for legal assistance are a sort of false economy. JusticeNet South Australia, they used to run a self-representation service, and they reckoned that service saved the state government $241,000 a year on $65,000 a year of funding. That service, though, had to be closed because there wasn't enough funding. When money isn't put into free legal assistance, there's a risk that those costs are just going to be transferred elsewhere and might end up much higher than they were when they were in legal assistance. For example, we might end up with cases without any merit not being filtered out by lawyers, or we might find delays because we have self-represented litigants in court. The limits on funding might end up, as well as being something that are less fair on litigants who can't afford access to justice, they might end up also costing the justice system and the government more overall. Many services like CLCs rely on volunteer contributions. And this is what's known as pro bono work. Pro bono publico, more Latin, translates to for the public good. And pro bono legal services are where lawyers work for the public good. They provide volunteer legal assistance, advice, representation, or they engage in community education or policy advocacy. This kind of work is a key part of a lawyer's professional identity. It can also be required by some jurisdictions or some firms, so it's worth getting a head start here. Law students can be a part of pro bono legal services, and that's including at CQ Uni. You're not yet a fully fledged lawyer, but already you know more than a non-lawyer does, and that means that you can support lawyers and CLCs in their provision of free legal assistance. Moving on to other ways in which we can improve access to justice, CCAs, conditional costs agreements, are a way of making legal costs more affordable, even if they don't make them cheaper. CCAs are this idea of no win, no fee. If you win the case, the lawyer gets the normal fee plus a success bonus, what's called an uplift fee. So you end up paying more if you win the case. That can be up to 25% more. But if you don't win the case, there's no lawyer's fees to pay. There is limited availability of these kinds of agreements. We do generally see them in relation to personal injury. And it's also a bit misleading here to call them no win, no fee. There are hidden costs in these conditional cost agreements, and those are called disbursements. Disbursements are the expenses incurred by the solicitor. They might be representation fees or medical reports, other kinds of reports, travel costs, those kinds of things are all disbursements. And they can add up to quite a lot, and you have to pay them regardless of whether your case is successful or not, because those disbursements aren't part of the fee. Then there's litigation funding, also known as litigation lending. And this is where a third party funds your case, with the loan repayable only if you actually win the case. A funder will usually demand that they be paid a proportion of the damages or a proportion of the settlement that results from the case. That might be between 1 and 2/3 of the amount awarded, so quite a lot. Litigation funding is something we usually see in class actions, in consumer, commercial and insolvency matters. They can be really important there. If you imagine a big class action case, you might have millions of dollars in legal costs, but your individual claim is probably just worth a few $1,000s as one person within a big class. So litigation funders, what they can do in these situations is take on the risk. Now, it was illegal, actually, before the 1960s for litigation funders to operate like this, for there to be this kind of funding. But since then, we've seen it expand as a way in which cases are funded. Litigation funding is controversial, though, because these funders aren't particularly well regulated, and it might not be the most ethical or effective way of doing things as a way of providing access to justice. These litigation funders stand to make a lot of money, and in doing so, because the way they make their money is through a proportion of the award, when litigation funders make money, that takes money away from litigants. The Australian Law Reform Commission found that when litigation funders were involved in a class action, the amount claimants themselves made in terms of from the successful case was 51% of the award, compared to 85% without a litigation funder in place. And there's one case in which a litigation funder made a 390% return on its investment. These kinds of situations are why the Attorney General, actually, the Federal Attorney General, is looking at more regulation of litigation funders.